Let me introduce to you our discussant, Mr. Francois Dubuisson, professor at the Université Libre de Bruxelles. He teaches courses in international and European intellectual property law, and it's the author of various articles published in national and international journals. Mr. Dubuisson also assisted Palestine in the case concerning the legal consequences of the construction of the wall in the occupied Palestinian territory. Mr. Dubuisson will make a few comments on the presentations we just heard and will help us trigger the discussions with some of the questions. Sir, I give you the floor.
Merci, Madame.
Thank you, Madam Chair. I would like to thank the committee for having given me the opportunity to make a few brief comments on the presentations that we have just heard. As will have become evident, the illegal nature of settlements is no longer in any doubt. There is a clear consensus in the international community, which has been documented in numerous reports, including that of the Human Rights Council Fact-Finding Commission. Each time, these give a very detailed picture, both in terms of facts and theory-wise, on the impacts of the settlements. So the question really then is the means and resources that can be deployed to ensure that Israel does respect international law. Here again, there is a fairly widespread consensus around the fact that settlements are the main obstacle to any peace settlement to the Israeli-Palestine conflict. If we look at the European Union, which is clearly an important actor on this front, an enormous number of statements have been made to this effect, and yet there is a lack of specific measures taken to uphold international law and to give a chance to what is generally held up as the only solution, that is to say, the two-state solution. In the next few minutes, I'm going to focus on an aspect that has been mentioned by several of the panelists, namely the obligations of third states under international law. I studied this. It was outlined in a report ordered by a number of NGOs. You can find this report in French in the documents linked to the conference, and there's also an English translation that you can find fairly easily on the internet, I think. There are, therefore, a number of obligations under international law linked to the illegal nature of the situation stemming from Israeli settlement building. There are three main categories of obligations that have already been mentioned several times this morning. There is the obligation of upholding international humanitarian law, and in particular, the prohibition of colonization. The obligation to not recognize the illegal situation created by colonization, and the obligation to not assist the maintenance of this illegal situation, and then something slightly new, a number of obligations outlined in the guiding principles adopted by the United Nations on the respect for human rights by transnational corporations. There are obligations incumbent upon these enterprises, but also on the states, the enterprises of which are under their jurisdiction. There are positive obligations for states who have to, as a result, adopt measures which aim to put an end to colonization. And these measures can be diverse. Chief among them would be prohibiting the import of products coming from settlements. This is an important step which, for the moment, most states refuse to take, and I'm speaking chiefly here about the states of the European Union. And then the other category of measures is positive steps to ensure that businesses under their jurisdiction are not allowed to engage in business with businesses that are based in the settlements or who engage in any activity which one way or another contributes to preserving and maintaining these settlements. If we look at European states, and I can see that there are a number of delegates here from European states, so I'm speaking to them in particular, we can see a altogether schizophrenic position by the European Union here. On the one hand, there are statements by the European Union and its member states saying that these settlements are illegal and that they are the main obstacle to any peace settlement, and at the same time they are only taking very timid steps to counter the colonization at a time when very more specific measures could be taken. And we're not talking about sanctions and boycotts. We're really talking here about respecting international legal obligations. From this point of view, what then are the examples of recent progress? We know that the European Union has adopted guidelines. It did this in 2013, 2 years ago now. These aim to ensure that Israeli entities established in the settlements can no longer receive financing, for example, in the context of European research initiatives. Now, probably these guidelines are being implemented in a fairly restrictive fashion by the European Union, but that was an initial step. But really, it only underscores the illegality of the European Union's prior practice. These guidelines were adopted because of this, and they've highlighted the fact that settlements were receiving financing, several millions of euros of financing from the European Union. So that's a first step forward, but it's not enough. The second timid step forward is, as Mr. Javarin said earlier, the lack of labeling products which come from the settlements, which would allow a consumer to recognize these products. But this is not sufficient and even paradoxical, because it highlights the fact that we know all too well that some products come from settlements, and so their origins are very closely linked to an illegal act, and nevertheless they are accepted on the European market, and say that it's up to the consumer to decide based on this labeling whether they want to buy them or not. This contrasts very strongly with another case adopted by the European Union in June 2014, a prohibition of products coming from Crimea and Sevastopol. Following the annexation of Crimea and Sevastopol by Russia, and this annexation was considered illegal under international law, the first measure that the European Union took within the context of its very specific legal system was to prohibit the imports of products coming from territories illegally annexed by Russia. And you can draw a very easy comparison between that annexation and the illegal annexation of East Jerusalem. And we see that what was decided here by the European Union underscores that this is an obligation under international law and should therefore be applied equally to products produced in the settlements. They should pure and simply be prohibited for import. We're not simply talking, rather this is merely the implementation of an international obligation. Another step that should be taken would be to be much more active vis-à-vis European enterprises which continue to have filials or offices, branches in the settlements, or which contribute to the maintenance of these settlements. These should lead to more specific measures in the future. I would underscore the adoption of the Human Rights Council resolution of March 2015. This resolution was adopted by 46 votes against 1, and the vote against is, of course, the one that voted against, for example, the report of the fact-finding commission, the United States. So the approval of all the European Union member states. This resolution underscores several things. Firstly, it recalls the obligations of third-party states under the Fourth Geneva Convention to uphold humanitarian law. It recalled the responsibility of enterprises, indicating that these enterprises given the illegal nature of the settlements, should not contribute to violations of international law by Israel, and that these enterprises should respect human rights and humanitarian law. So very directly, they are given responsibility, these businesses have a responsibility, and that they have to take measures to prevent that. And there is an explicit reminder that economic activities conducted in these settlements contribute directly to the construction and expansion of colonization. So this recognizes the intrinsic link that exists between economic activities conducted in the colonies and the fact that this contributes to the legal situation. So all that's missing is the last step in the logic here, namely that the next step is to prohibit imports from the settlements and not simply to leave that choice up to the consumer. Thank you.